Welcome everyone to the first class on Sales of Good Act 1930. Let me start with a question. Have you ever wondered what legal framework protects you when you buy something as simple as a phone or a cup of a coffee when you go to a cafe? What ensures that the seller delivers what they promise? And what rights do you have if things go wrong? The answer lies in a law that impacts our everyday transactions. That is the Sale of Good Act 1930. This act almost governs every sale or purchase we make, from buying groceries to major business deals involving large quantity of goods. Before 1930, the sale of goods was regulated under the Indian Contract Act 1872. However, the increasing complexities of trade and commerce made it necessary to have a separate law to deal with such transactions, which led to an enactment of Sales of Good Act on July 1st, 1930. So let's begin with today's class and understand what we are going to study today. What you'll be learning. Module 1. In today's class, we are going to understand Introduction to the Sales of Goods Act 1930. Later on, in upcoming classes, we will cover Module 2, 3, 4, which are based on transfer of ownership and risk, performance of contract and remedies, and special types of sales and miscellaneous provisions related to Sales of Good Act 1930. So now that we have understood the entire course structure, let's move on to the next slide. Module 1. In week first, we will discover the history and evolution of Sales of Good Act 1930. Importance and relevance in commercial transaction, key definitions of different terms under the Act, example, good, seller, buyer, price, the distinction between a sale and an agreement to sell. Then in the week 2, we are going to cover conditions and warranties. Conditions and warranties, what are the definition and types of conditions and warranties? Implied conditions and warranties in sale contract. Now, let's talk about our today's topic, history and evolution of Sales of Good Act in India. As we have already discussed, before 1930, the Sales of Good Act was regulated under the Indian Contract Act 1872. However, because there was a need for a particular law made for trade and commerce, it was necessary to have a law to deal with such transactions, which led to enactment of this particular law on July 1st, 1930. Right? The Act, Sales of Good Act, is largely based on English Sale of Goods Act 1893, and it ensures the Act, that is the Sales of Good Act, is largely based on English Sale of Good Act 1893, and it ensures that both buyers and sellers in India are treated fairly. So what were the drawbacks which led to the invention of this particular Sale of Good Act? Its distinct characteristics, protection of rights and interests, gaps in general law, contract law, commercial and economic development, which was growing faster day by day. And there was a need for clarity and consistency in the law related to sale of goods. So this is what led to the invention and the passing of a separate legal act for sales of good in India. So until 1930, the law governing the sale of goods in India was part of Indian Contract Act, particularly Chapter 7, which dealt with contract related to sale of goods. In response to these complexities, the Sale of Good Act 1930 was enacted based largely on the English Sale of Good Act 1893. The Indian legislature found it necessary to bring clarity and uniformity to commercial transactions involving goods. The Act came into force on July 1st, 1930 and marked the first significant move towards creating a legal structure that governed the rights and obligations of buyers and sellers in a sale transaction. Let's move on to the next slide and understand the key consideration or features of the Indian Sale of Goods Act. The Sale of Good Act. The sale of goods refers to transfer of ownership of tangible items from a seller to a buyer for a monetary consideration known as a price. What is sale of goods? The sale of good refers to first, that is transfer of ownership and of a tangible item from a seller and a buyer. So the parties to a sale of good are called as a seller and a buyer. And this transaction of the tangible item should be done in exchange of money. There are three key elements that define any valid sale of goods. First is goods. The subject matter of the sale must be tangible, movable items. Second, there must be ownership, which is transferred from one party to another party and must occur between seller and buyer. And third is the price. The exchange must involve a price which must be monetary. Let's take an example. Imagine a customer purchasing a car from a dealer. In this case, the car is the goods. The buyer becomes the owner upon payment, and the payment made or the price paid is the price. This transaction is governed by Sales of Good Act. But what if the car is sold without engine working properly? Can the buyer ask for a refund or cancel the contract? The answer depends on conditions of sale, which we will get into shortly. It is important to note that only movable property qualifies as goods under this act. Services, real estate, and even money itself are excluded. Let's look at what can and cannot be considered as goods under the law. But before that, let's have a look at the key features of the Act. The key features of the Act, the Sale of Good Act 1930 contains provisions that define key elements of a sale, such as the formation of contract for sale of goods, the distinction between a sale and agreement to sell, transfer of ownership and property from seller to the buyer, the role of conditions and warranties in the contract for sale, and remedies available in cases of breach of contract. Moving to the next slide, what are the current legal framework that deal with the Sale of Good Acts or are considered when you are dealing with a contract for sale of goods? First is the Consumer Protection Act 2019. Then comes the Indian Contract Act 1872 and the Goods and Services Act, that is GST Act 2017. Let's understand the relationship between Contract Law and Sale of Goods Act 1930. So, Contract Act or the Contract Law and Sale of Goods Act are interconnected. Okay. The scope here deals with when you're dealing with a contract law, it governs all type of contracts. But when you're dealing with the Sales of Good Act, it deals only with selling and purchase of goods, movable, tangible commodities. Here, the feature which defines the principle in contract law, general principle for offer, acceptance, consideration, and intent to create legal relationships are important. But when you deal with Sales of Good Act, the principles such as something that incorporates the similar principles as contract law, but are more specific to goods issues. Okay. Then comes the provision. The contract law provides a general framework for contract act. But the Sale of Goods Act includes specific provisions related to implied terms, conditions, warranties, remedies, and transfer of property. how the sale will take place, how the goods will be provided, what are the rights of the buyer, what are the rights of the seller, specific to when the sale is for goods and commodities. Then comes the feature of relationship. The Sale of Goods Act is a subset of contract law. The Sale of Good Act builds upon principles of contract law and addresses the unique aspects of goods transaction. So, sale of goods is actually a child of contract law, which specifically deals with sale of goods. Now, let's move on to the next slide. Here, we are going to see the purpose and definitions of key terms of the Sales of Good Act. Concept of goods. According to the section 2(7), good means every kind of movable property other than actionable claims and money, and includes stocks and shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be served before sale or under the contract of sale. So this is the legal definition of what goods are. Okay, let's take an example. A farmer selling standing crops agrees that the buyer will harvest them after the purchase. Even though crops are attached to the land, they qualify as goods under the act because they will be served before the delivery. Then, to understand it even better, let's take another example. Let's say a music company sells the copyright of a famous song to a movie production company. Even though the copyright is intangible, it qualifies as goods under this act because it is a movable property. However, money in its legal tender form is not considered as goods. For example, if someone attempts to sell cash, the transaction wouldn't fall under the Sales of Good Act. Similarly, actionable claims like debts are excluded. So here, if you see, the legal definition of goods makes a clear distinction between what is included and what is excluded. All types of movable property, stocks, share, growing crops, things attached to earth or forming the plant part of land which can be served before a sale or under the contract of sale. Then, what is the list of what is excluded? Actionable claims and money. Money, which is the legal tender, example, goodwill, copyright, trademark, patents, water, gas, electricity, stamp, interest of partners in firm are excluded from the concept of goods. Let's move on to the next slide and understand what are the types of goods. Existing goods. Goods which are physically in existence and which are in seller's ownership or possession at the time of entering the contract of sale are called as existing goods. For example, if a person buys a laptop from a store, the laptop is an existing good. Now that we have understood the existing good, let's move on to future goods. Goods to be manufactured, produced or acquired by the seller after making of the contract of sale are called as future goods. Section 2(6) of this act deals with future goods. These goods may be either not yet in existence or be in existence but not yet acquired by the seller. For example, A agrees to sell B all the milk that his cow may yield during the coming year. This is a contract for sale of future goods. Now that we have seen what are future goods, let's understand contingent goods. Though a type of future goods, these are goods the acquisition of which by the seller depends upon contingency which may or may not happen, which is governed under the section 6(2) of this act. So basically, any good which has an contingency attached to it is called as contingent good. Contingent good depend on an uncertain event happening in future. For example, let's say a person agrees to sell a rare painting to another person. but the sale is contingent on that person being able to buy it from the current owner. If the person who's selling it fails to acquire the painting, the sale won't go through. It is a classic example of contingent goods. We have seen and covered the three types of goods according to the Sale of Goods Act. Let's move forward and understand what is the seller according to the Act. The Section 213 of the Sales of Good Act 1930 defines a seller as a person who sells or agrees to sell the goods. The seller is a party to the contract of sale who transfers or agrees to transfer the ownership of goods to the prior. The seller is the party in the contract of sale who transfers or agrees to transfer the ownership of goods to the buyer for a price. The seller could be the owner of the goods, or they might be someone who has authority to sell the goods, such as an agent or a person who has possession of the goods under the contract that gives them the right to sell them. The role of the seller is to deliver the goods as per the contract terms, ensure the transfer of the property, the ownership, and fulfill all obligations outlined in the contract, including delivering goods free from all defects and complying with all warranties and conditions. Let's see what is a buyer according to the Sales of Good Act. Now let's move on to the next party, that is the buyer, and the legal definition of buyer according to the Sales of Good Act. Section 2(1) of the Sales of Good Act 1930 defines a buyer as a person who buys or agrees to buy the goods. The buyer is the party in a contract of sale who purchases or agrees to purchase the goods from the seller in exchange for a price. The buyer primary obligation is to pay the agreed upon price for the goods and accept the delivery of the goods as per the terms of the contract. A buyer can be an individual, a corporation, or any entity capable of entering into a contract. The buyer must have the legal capacity to contract as per the Indian Contract Act 1872. Let's see what is price and how it is defined under the Sales of Good Act 1930. So, the Section 210 of the Sales of Good Act 1930 defines price as the monetary consideration for sale of goods. Price refers to the monetary consideration agreed upon by the seller and the buyer for transfer of ownership of goods. The price can be fixed by the contract itself and determined by the manner provided in the contract, or left to be determined. The price can be fixed by the contract itself, determined by the manner provided in the contract, or left to be determined by the course of dealing between the parties. If the price is not determined, then the buyer is bound to pay a reasonable price, which is the price determined based on the circumstances of each case. The price must be in monetary terms. If goods are exchanged for goods, it does not constitute a sale under the Act, but is rather a barter. A valid contract or sale must involve a price paid in money, either in full, in part, or through credit arrangements. So far, we have discussed the legal definition and understood the concepts of Sale of Good Act in detail. That is goods, seller, buyer, and price. Let's move on and understand what is a contract of sale. Contract of sale. A contract of sale is a generic term. It is defined under Section 4 as a contract according to which a seller transfers or agrees to transfer certain goods to buyer for a given sum of money known as price of the good. The contract for sale is used to refer a sale and an agreement to sell. Now let's see what are the essentials of contract for sale. For a contract of sale to be valid, several essential elements must be present. Two parties. There must be a distinct buyer and a seller. Both parties must be legally competent to contract as defined under and by the Indian Contract Act 1872. For instance, a contract with a minor or a person of unsound mind would be void. Then the second essential element of the contract for sale is goods as the subject matter. The contract must involve goods as defined under the Sale of Goods Act. For example, if A agrees to sell his car to B, the car is the subject matter of the sale and it is a valid contract under the Sale of Goods Act. Then comes the third most essential element of a contract for sale of goods, that is monetary consideration. The price must be monetary. If goods are exchanged for goods, it is a barter transaction and not a sale under this act. Then fourth, last but not the least, the most important element is consent. Free consent must not be obtained through coercion, fraud, and undue influence. If the contract is made under duress, it becomes voidable at the option of the party whose consent was compromised. Example, if A threatens B to sell the car at low price, the contract would be invalid because B's consent was obtained under coercion. Now that we have understood the essential of contracts of sale, let's move on to the next slide. Sale and agreement to sell, where the seller transforms the ownership rights to buyer immediately on making the contract. It is the contract for sale. But where the ownership rights are to pass on some future date upon fulfillment of certain conditions, then it is called as an agreement to sell. Let's understand this with an example. Example for sale. If you buy a phone and pay for it at the store, ownership transfers to you immediately. You now bear all the risk and benefits associated with owning the phone. Example for agreement to sell. A agrees to sell his bike to B, but the ownership will transfer only after B pays the full price in installment. So until B completes the payment, the ownership remains with A and contract remains an agreement to sell. Let's move on to the next slide and understand the features of both. Definition: there is an immediate transfer of ownership in sale. There is a future transfer of ownership in agreement to sell. Transfer of ownership is at the time of contract in sale. Transfer of ownership is upon a future date or upon fulfillment of any condition in agreement to sell. Then transfer of risk is immediately given to the buyer in sale, but transfer of risk is upon transfer of ownership in agreement to sell. Nature of the contract: sale is already executed and agreement to sell is executory, to be executed in future upon conditions are fulfilled. Consequences of breach by buyer: seller can sue the buyer for price in sale. Seller can sue for damages in agreement to sell. Rights of the parties: in case of insolvency, sale, goods belong to the buyer in insolvency, but in agreement to sell, goods will remain with the seller. And right to resale in sale are not available, but right to resale in agreement to the seller are available. Legal remedies under the sale are sue for price, lien, stoppage in transit. And agreement to sell, only you can sue for damages. So this is the major difference between sale and agreement to sell. Sale is in present and agreement to sell is a promise made to fulfill in future. Now that we have understood this, we come to the end of today's class. So to wrap up, the Sales of Good Act 1930 provides a comprehensive framework for all transactions involving the sale of goods. It defines the right and obligations of both buyers and sellers, ensuring that all commercial dealings are fair and just. Whether you're buying a loaf of bread or negotiating a multi-million rupee deal, this law is there to protect both parties and ensure smooth transactions. I hope you now have a clearer understanding of how the Sale of Good Act works and how it applies to real life situations. Thank you for your attention and feel free to reach out to us if you have any questions, as this is a recorded session. Thank you once again. Speak legal, speak weightage. I'll see you in the next class. Till then, bye bye.